Hi, welcome to the legal wing of Perchance to Read, where I read one word or legal term and quickly break it down for trial watchers. As I say each time, there's no focus on any one trial in this series, just the trial words. And as always, nothing in this video is intended to be legal advice to anyone about anything. Okay, let's jump right in. I think motions are worth talking about because I keep hearing hosts on TV who aren't lawyers mixing up terms and getting things a bit wrong, especially as motions gain traction and parties make subsequent filings. I'm hoping to clear it up for trial watchers. So here goes. A motion is simply a grand yes or no question that a party or proposed party to a case asks the court. The motion may have a long title and ask for many things that may be complicated to achieve, and the motion may take a while to decide, but in the end, the court is either going to give some version of a yes answer, motion granted or granted in part, or some version of a no answer, motion denied or denied in part. When a party files a motion, for that action, the party is called the movant. They keep their other role within the larger action, whether that's plaintiff, defendant, intervener, objector, cross-complainant, etc. But for specifically the filing of the motion, they're referred to as the movant. The verb for the act of filing the motion is to move the court, and not to motion the court. So you move a court when you file a motion, you don't motion the court. Parties file motions when they need something to occur in a case that wouldn't naturally occur in the normal process of the case because the rules or law have already factored it in, like say in a criminal case, where you wouldn't need to file a motion for the defendant to avoid testifying at trial because a defendant is protected by the Fifth Amendment from having to testify. But if, say, in a civil case, a party feels there is no debatable issue in the case, and they want to skip the trial phase and ask the court to decide in their favor and grant a summary judgment, meaning they win without there being a trial, that party must move the court for summary judgment. They must file a summary judgment motion. Summary judgment motions are extremely common and they are even regularly granted. In fact, I did a separate video on summary judgment motions, so I won't go over them in detail here. They're just an example of a type of motion that might be filed in a case. Other common motions include motions for a specific trial or case schedule, motions to exclude evidence, which are called motions in limine, and those are so common and literally part of every trial that I did a short separate video on those too. Motions to compel a party to act, motions for certain types of discovery, motions for sanctions to be imposed on a party or an attorney, and I have a sanctions video as well, motions to dismiss, motions for a stay of an order or an entire case pending some other process playing out, motions for relief from an earlier default or error made, motions to file documents under seal, motions to unseal earlier sealed documents, etc. There are endless numbers of motions, grand yes or no questions that parties can file in a case. And they don't have to be filed on paper. If you've watched enough legal dramas, you've seen a witness answer an attorney's questions, and then you've seen the other attorney jump up and say, "Move to strike." They're moving the court to strike the answer or response to the question right there on the spot, no papers filed. Here's the part where TV hosts discussing legal matters are kind of getting it wrong, thus this video. When the other side opposes the motion, your favorite YouTuber or podcaster that you regularly tune into for trial coverage, who's likely an experienced lawyer, has got it right. I watch them too, and they get it right in their sleep. I'm not here about them. It's those folks hosting TV shows interviewing legal analysts who could use a primer on motions before discussing them on air because they not only confuse what's filed, but they confuse what those filings mean and arguably confuse their audiences. So let's clear it up and listen up, TV hosts. The party who opposes a motion files what's called a response or an opposition to the motion. They do not file a reply to the motion. Let me say that again. They do not file a reply to the motion. A reply is something else that is its own legal thing that I'll get to in a moment. So the opponent files a response or an opposition to the motion. I'm going to stick with opposition for now. That term, opposition, matters because it signifies what the underlying or anchor filing is. So if I see that an opposition was filed, I know that it pertains to a motion. Here's the thing. In an opposition, the opponent will argue for the opposite outcome that the movant seeks. However, and this is where TV hosts keep getting it kind of wrong and confusing people in my opinion, the opponent is not filing their own motion in the opposition. I keep hearing, and in their motion, the other side said. That's confusing. It's not another motion. Yes, the opponent in their opposition will say, the movant asked for X, but we would ask the court do Y instead. But that's not itself a motion. It's opposition to the original motion, simply asking the court to do something different from what the motion asks. It follows that the opponent will ask for opposite things or different things from what the movant asks, but the opponent doesn't morph into a movant. They're still an opponent. It matters because if there were two motions, we'd be waiting for two rulings from the court, and the other side would technically need to be given time to file opposition to this so-called new motion. But that's not the case. We're waiting for one ruling on the one motion in play. So I really need TV hosts to stop saying, and in their motion, when talking about opposition to a motion. As I touched on earlier, they'll also call the opposition a reply to the motion, which is very incorrect. I know incorrect is an absolute, but I still need the adverb very for this one. It's very incorrect to call a response or opposition to a motion a reply. Instead, if the movant wishes to respond to the opposition, that document is called a reply to the opposition. The movant files the reply to the opposition. Reply. Opposition and reply are not interchangeable terms. A judge may randomly ask a clerk, and not just a law clerk, but the actual clerk who file stamped the document, where's the reply? And every version of clerk knows the judge is talking about the movant's reply to the opponent's opposition. Not one clerk would ask, wait, Your Honor, wait, what do you mean? Do you mean the other side's opposition or what? No. Everyone knows it's the movant's reply to the opponent's response or opposition because the judge said reply and we're done. The terms matter. Usually a movant must request permission to file a reply to the opposition. The court may not want to hear a rebuttal to the opposition from the movant and will generally cut it at motion and opposition. But if you're trial watching and you know an opposition was filed, you may have to wait for the outcome because the movant may ask to file a reply, and there's a good chance that the court will grant that request. Okay, here's where I get a lot less impatient. In fact, all my patience returns here, because these next two filings are rare and the terminology is odd. If the movant files a reply, the opponent may want to file a response to the reply. And this is where just about everyone kind of falls off the terminology tracks. Many people, including lawyers and judges, will call this next filing, the one that comes after the reply, a sur-reply, sometimes hyphenated. Sur means over, above, or on top of. So people tend to think that this response by the opponent as being on top of the movant's initial reply, thereby resulting in a sur-reply. But it's actually a supplement to the opponent's initial response or opposition. So it's on top of that response or opposition, and therefore properly referred to as a surresponse. I know lawyers may be out there kind of shouting back at their device as they're watching this saying, no, it's a sur-reply. But no, it's a surresponse. In fact, Black's Law Dictionary defines a surresponse as a second response by someone who opposes a motion. The dictionary folks explain right there in the definition that a surresponse comes in answer to the movant's reply. So what is a surreply? The surreply is actually the movant's answer to the Surresponse that comes on top of the Movant's original reply, so it would be the Movant's sur-reply, and the fifth filing in this motion proceeding. We have a motion, an opposition, a reply, a Surresponse, and a sur-reply. The Movant files the sur-reply. Black's Law Dictionary defines a sur-reply as a movant's second supplemental response to another party's opposition to a motion, usually in answer to a surresponse. There are even cases out there that discuss these filings using these terms. However, a ginormous portion of the legal community will call this filing, the one that comes right after the reply, a sur-reply. And I've even heard the fifth filing, that last thing that's filed, called the sur-reply, which is not a thing. But no slam on those folks. In actual filing practice, usually the farthest we get is the opposition, the filing of which is likely provided for in the rules of court in the jurisdiction, with a reply allowed some of the time. Surresponses and surreplies are rare filings, especially since they generally require getting permission from the court before filing them. In its definition of surresponse, Black's indicates surresponses are rarely allowed. Even when all 5 of these things are filed, we're still just dealing with one motion and waiting for one ruling. It may include some wins and losses for each side, with multiple orders and directives in the final ruling, but it's still just a closeout of one motion. And there you have it, motions. If this was helpful, please hit that like button. Links to my other trial watchwords are above and in the description. Links to my traditional channel material are also in the description. And it bears repeating, nothing in this video is intended to be legal advice to anyone about anything. Thanks for watching.